Good afternoon, everyone, and welcome back to this week's episode of Digital Law News produced by Anson Evaluate. I'm Amelia Davies, an apprentice solicitor at Digital Law UK. I'm joined by my colleague, Peter Wright, and we're just going to run through some news stories which are coming up this week. I'll pass over to Peter to introduce himself, and then we'll get started.
Thanks, Amelia. Yes, so my name is Peter. I'm a solicitor and the managing director at Digital Law, and we have got a lot of stories to update you on after the last 2 weeks. So, in particular, covering things like Ukraine and also some developments when it comes to sharing international data transfers from Europe to the US. So I'll hand back to Amelia to kick us off.
Thanks, Peter. So our first story today is in Ukraine. So Ukraine's national telecoms operator, I'm going to have to apologise here, I can't actually say the name of this. I'll let Peter fill in that one when he goes through this here. So they are restoring internet services after driving back a major cyber attack. So the company has said that it restricted customer access to protect military users and critical infrastructure. The global internet monitor NetBlocks has said it's the most severe disruption to affect the Ukraine national telecoms since Russia's invasion of Ukraine last month. It has said that it saw a collapse in connectivity to 13% of pre-war levels. However, Ukrainian users on different internet providers who've spoken to the BBC have reported no problems. So I will pass over to Peter to continue with this one.
Thank you, Amelia. So Ukr Telecom is trying to restore services after having them reduced to 13% of their connectivity pre-war. I think it's been a feature of the conflict so far that it's actually been quite surprising that networks have remained operational in the volume and extent that they are, which is one of the reasons why we've seen a lot of sharing of coverage on social media from those actually experiencing things in Ukraine on platforms like TikTok, and being able to upload video instantly and share it in terms of what's happening in Ukrainian towns and cities as they are under bombardment and attack from Russia. And I think many people have been surprised, at the fact that Ukrainians have been able to share this information, and that Ukrainians who've then had to leave their towns and villages and cities, in many instances, have been able to stay in contact with other friends and relatives who haven't been able to leave. So the huge amounts of traffic with people relying on that internet connectivity. And so far, over the course of the last month of heavy conflict, those networks have held up. There has been a suspicion that the invading forces have resisted the temptation to take these networks down, because in many instances they've been able to track not just sort of mobile phone users to work out where the population centres are and where people may be, where they can find people, but also in particular they could find individuals. And there was a suspicion that squads that were being sent to search for the Ukrainian leadership were doing that based on being able to track the specific mobile phone IDs of the Ukrainian government and cabinet ministers, as well as the president. But in this instance, it looks like increasingly, as we're seeing in this conflict, the gloves really are off. You get this level of escalation where almost tit for tat, things get worse and worse, atrocities by different sides, and in this instance, or misunderstandings as well. In this instance, it looks like the decision has been taken by the invading forces that they will take down this large provider. It is to be hoped they are able to restore that level of connectivity, given, as I say, so many people are relying on it, not least the several million Ukrainians displaced by the conflict, who of course are in many cases frantic to find news of family, friends and loved ones who are still in Ukraine and dealing with the increasingly difficult living conditions there.
Thanks, Peter. So staying with Ukraine, kind of the opposite side of the spectrum now. Phishing scams fundraising for Ukraine have been popping up. So Action Fraud has revealed that it has received 196 reports of scam emails purporting to raise money for those affected by the conflict in Ukraine. Fraudsters have used a variety of methods in order to get potential victims to part with their cash, including selling T-shirts and soliciting cryptocurrency donations. This is quite a harrowing story, really, because you've got this major conflict that's going on, and criminals are trying to use this to their advantage in order to scam people out of their money. I'll pass over to Peter with this.
Thank you, Amelia. I mean, given the record levels of fundraising that have taken place over the course of the last month, where people have been raising money for people in Ukraine affected by the conflict in particular, when you've got large amounts of money suddenly swirling around, it then does become the danger that you could end up funneling money to a fraudulent source. I think for those of us in the UK who are wanting to make sure our money goes to where it's needed, we should be looking really at the Disaster Emergencies Committee, and they have the specific lines of funding, and indeed our firm, we supported an event a couple of weeks back for Ukraine, and money there was divided between the Disaster Emergencies Committee and War Child. So at least we knew that the firm was that the money was going to the verified sources for those fundraising purposes. And the government has got its gov.uk/check charity to be able to confirm the legitimacy of any charitable giving links that you may be wanting to use. And of course, if you end up receiving a fraudulent email soliciting donations, then that should be sent to report@phishing.gov.uk, and that is official guidance from both the National Cybersecurity Centre and Action Fraud. In the same way that we should be hyper vigilant before entering payment card details online when we're buying anything, we should be really applying the same levels of vigilance when it comes to charitable giving, regrettably, as well, just to make sure that the money is actually going where you want it to go, i.e. to support those who've been affected by the conflict.
Thanks, Peter. So our next story today is looking at the EU and US data transfer. So the European Union has just announced that they've been reaching an agreement in principle with the US on revived transatlantic data flow deals. And I will hone in on the word agreement in principle there. So this could potentially signal an end to many months of legal uncertainty between the two after the Privacy Shield was struck down. I will pass over to Peter to go through this in more detail.
Thanks, Amelia. Would you like to take us through in detail the outcome of the Schrems II decision and how we've got this far?
So Max Schrems, thanks, Peter. So Max Schrems, initially, there was Schrems 1 and Schrems 2. Schrems 1 they've both taken down both of the privacy deals. And as a result, at the moment, there has not been a data flow agreement. This is because when we were looking at Schrems 2, there was a lot of issues, really, and effectively there was, while we in the EU have GDPR, there was not really the same level of compliance displayed in the Privacy Shield, and therefore Max and his Schrems, they very heavily criticised it to the point that it was then struck down in July 2020. And therefore, ever since, there hasn't really been anything that's been protecting the data transfer between the EU and the US.
Indeed, indeed, good response. So I put you on the spot there, Amelia. The key thing there is that indeed this is twice now that through litigation, Max Schrems has led to the collapse of the systems governing international data transfers of EU data subjects from Europe to the United States. The Schrems II decision, without going into too much granular detail, is because of the fundamental problems, as you quite rightly said, Amelia. There are not the same standards in terms of the protection of data. So listeners may be familiar with the California Consumer Privacy Act and the forthcoming California Privacy Rights Act. But the point is that those only apply in California. There is no federal data protection law, therefore no basis that the European Commission could make an adequacy decision to the United States in the same way it has for countries like the UK and Japan and Canada and New Zealand. So therefore, there's been this sort of succession of ramshackle agreements, of which the EU-US Privacy Shield was the most recent. And one of the reasons that was struck down in Schrems 2 was because of concerns over the level of US government surveillance. So they can carry out warrants under the Foreign Intelligence Surveillance Act that could mean that the data that some organizations could be storing of EU citizens on infrastructure in the US could still be subject to these bulk FISA warrants. So as a result, even though these companies are signing up to the Privacy Shield and saying, yes, we will look after data in accordance with the protocols of the Shield, and we will ensure there's no onward data transfer, and we'll ensure that it isn't being kept for longer than necessary, and we'll ensure that we aren't collecting more data than we have to, and we'll abide by the decisions of the ombudsperson who is regulating and enforcing the scheme. It was felt that that was all well and good, but it still didn't mean that various agencies couldn't be executing FISA warrants on that data. Since the Shield went down, there's been the fun of standard contractual clauses or binding corporate rules that organisations could use, but of course the same things would apply insofar as if you were relying on BCRs or SCCs. That didn't mean that these warrants couldn't still be being exercised, and that while you go to all the trouble of putting standard contractual clauses in place, it didn't mean that that data couldn't still be under surveillance. So we now find ourselves with a new agreement reached between Ursula von der Leyen and President Biden saying this has all been resolved. I thought that this would happen quite quickly. I think that this is one of the outcomes of the fact that the West collectively has realised that if we cannot find a way to work, so between the countries of Europe and the US and others, if we can't agree ways of working when it comes to technology, sharing data, artificial intelligence, etc., the regulation of tech, if we cannot work out ways to do this in the West, we risk ceding the advantage and ceding the ability to set clear standards that the rest of the world could seek to follow to other players. And I won't go into detail on who that could be, but the point is that if we end up with Europe and America at daggers drawn, shouting and yelling insults at each other, it's not really benefiting anyone. So there's been a certain focusing and concentrating of minds over the course of the last month, as the West has collectively realised that the world isn't quite as perhaps safe and unipolar as many Western countries thought. And therefore we have this new agreement, though what has been announced is painfully thin in actual detail. They haven't actually published what it is they've agreed to yet. Two very different legal systems. It looks like this is literally sort of the son of Privacy Shield agreement, so it's going to be the same Privacy Shield with more beefed up requirements, though how this will circumvent the problems highlighted in the Schrems 2 decision, we have no detail in terms of what is being done to show that this will make any difference. And the problem here is that politicians and leaders can get together and have a photo op and shake hands and say peace in our time isn't this wonderful. And then when it comes to the scrutiny of what they've agreed in the European Court of Justice or the US Supreme Court for that matter, there is always going to be the risk that what has been agreed in the photo op isn't actually going to stand up to scrutiny when you try to apply the privacy rights that are established in Europe and say that these are not being threatened by data then being stored in the United States. And that is the fundamental problem. My personal view is that if there had been a proper agreement in terms of the transatlantic trade and investment partnership between Europe and America, I think that would have probably paved the way to a proper concerted agreement in terms of data protection and data rights for both Americans and Europeans. It was such a comprehensive document, and it would have probably ensured a degree of equanimity in terms of both jurisdictions that I think agreement would have been possible, and you probably would have had something like something that you could have hung in effect a US federal data protection law from. But of course, that whole process was stillborn the minute in 2016 that President Trump was elected, and he said that was one of his key election campaigns: no transatlantic trade investment partnership and no trans-Pacific investment partnership either. So as a result, we're left with this sort of fracture between Europe and America, And this new Privacy Shield system, whatever it is, remains just really a sticking plaster on what remains a massive problem between both blocks, and we'll have to see if it actually works. There may be now the political will on both sides of the Atlantic, though however long that lasts, we may as well, that's pretty much up in the air depending on political developments in both Europe and the US. But I have a horrible feeling that the first US Safe Harbor Agreement lasted for 15 years and was struck down in 2015. The Privacy Shield is then, RIP, that was 2016 to 2020. So barely 4 years of operation, and during that time, the committee overseeing its operation kept on submitting reports saying this isn't working well enough. And then now we have a new arrangement. Hopefully that will be online in 2022, but at the moment, on that trajectory, is it going to last 4 years? If we're lucky, it might depend how long any challenge takes to work its way through domestic courts and get up to the European Court of Justice or the US Supreme Court. It may not last very long. It remains to be seen.
Thanks, Peter. Staying in America, our next story is based in New York. So New York's business elite was left shaking in its boots Tuesday after a list of alleged clients of the student prostitute Sarah Lawrence, the sex cult case, was inadvertently published online. So the list was entered into evidence in the trial under seal, and it includes lawyers and businessmen as well as socialites throughout the tri-state area. A copy of the list was acquired by the Daily Mail, and it had 121 names listed on there. Although the list was taken down nearly as quickly as it has been put up, there was some pretty glaringly obvious names. There was a top executive at the Gap clothing firm, as well as her husband, who was one of the two married couples included. Former New York State Supreme Court judge, who is also named, with various other prominent figures also involved. This is sort of a different sort of story that we'd normally cover, because typically when you're thinking about data leaks, it's normally due to ransomware, whereas this, by the looks of things, is just down to human error. I'll pass over to Peter.
Thank you, Amelia. Human error accidentally on purpose. Remarkably convenient, isn't it, that this information has been published, and the long list of the powerful and influential that it features. You can't help but think that, if it included people that we'd never heard of, or didn't, if it included the person who operates the toll booth on the on one of the tunnels in New York, I don't think anyone would be that bothered. But when it's people that work for and run big corporations, and people in authority and politicians, suddenly everyone's very, very interested. So it's entirely coincidental that usually when sealed documents like this remain under seal, and getting them out from being under seal is usually incredibly difficult, despite what you may have seen in Suits and other US dramas. This stuff usually, once it's under seal, it remains under seal, and getting it not under seal is difficult / impossible. So therefore, remarkably convenient if it's then suddenly leaked and then accidentally on purpose finds its way to the dailymail.com. The thing here is clearly lacks standards within the US Department of Justice that led to this being leaked. From the inherent sarcasm there, you'll see that it's my view that that's not exactly accidental. So you've then potentially got someone within the DOJ who has deliberately leaked this to the press. And in terms of the correct operation of justice, the court had that document sealed for a reason. And while it's a little bit of titillation almost to say, oh, look who ended up being on this list, imagine instead that we were looking at something that, say, involved child care proceedings or child abuse or other vulnerable people. And if you've got this sort of information being sealed by the court, it's there for a reason. And the fact that that has been, in effect, that has been circumvented, and there's been some pathetic attempts to then try and we sort of roll it back. So the DOJ saying, if you've received this, please delete it and don't open it and don't forward it on anywhere. Well, sorry, that's obviously closing the stable door after the horse has bolted many days previously. Simply too late. The thing had been posted on Twitter So yeah, kind of everyone who was interested in it will have seen it, will have grabbed it, will have screenshotted it, will have made multiple copies. So it's out there, and once it's out there, you can't undo these things, unfortunately. And in the meantime, this is part of an ongoing piece of criminal litigation that has potential to be incredibly damaging. So yeah, not a great story for the DOJ, but I think the so what here is that judicial systems all around the world cannot allow these sorts of things to happen. Certainly they can't allow it to happen willfully or easily. So really it's a matter of actually, when this stuff is properly sealed, if it's not meant for publication, there need to be mechanisms and processes in place to ensure that that does not happen, whether there is a willful leaker there or not.
Thanks, Peter. I think it's worth mentioning here that if you are familiar with the Sarah Lawrence case, this case in itself has had a lot of media coverage due to the fact the people involved, there has been, the accused has actually collapsed twice in the courtroom, which is extremely unusual in relation to this case, and has ended up in the ambulance. So already there is this big media speculation here. And this is kind of adding insult to injury at this point, with more and more coming out. And when we're looking at the justice system here, when we've already got this chap kind of collapsing in the courtroom, and now we've got the addition of this list that has been published. In law, we do have the jury, and the whole point of the jury is they're supposed to not look at the media. And when we've got all of this kind of coming out, it is going to influence their decision, and trying to stay away from this media coverage is going to be increasingly difficult. And when a case such as this, you've got a jury that potentially will be able to form their own opinions due to the media coverage, it does kind of defeat the whole purpose of having a jury, and it could end up with the miscarriage of justice. So it's a sad time to hear that this has been leaked.
Indeed.
Moving on to our next story, kind of sticking with the theme of breach. A partner at a commercial firm breached the embargo on a draft judgment by sending the results of an appeal to a social WhatsApp group containing dozens of international lawyers. So Keith Oliver, an international fraud litigation specialist at Peters & Peters, has expressed deep regret for his actions and provided a full apology to the court, Lady Justice Carr said in the ruling. Oliver represents a former partner at a Swiss bank Piquet in ongoing high-value litigation concerning the alleged corruption of the former Director General of Kuwait's Public Institution of Social Security. So earlier this year, the Court of Appeal dismissed PIFSS appeal on jurisdictional issues in a ruling which was sent in a draft on the 18th of January. That same evening, Oliver attempted to send a message to a group chat used for confidential messages between senior partners at his firm. However, he did not send the message to his fellow partners as he intended, and instead sent the message to quite a different group of 41 international lawyers, which was created for social reasons. There's a fair amount to unpick here, because for a start, on the surface, he has obviously breached an embargo. Then secondly, social media and WhatsApp being used for confidential information is yet another red flag here. And then going on to the fact that 41 international lawyers have now also seen this embargo. There is a lot of unfortunate happenings in this event.
Indeed, and I think this very timely demonstrates the danger of using WhatsApp. We know that sadly the Prime Minister and various government ministers seem to habitually use WhatsApp and engage in WhatsApp groups and share information. But one of the dangers is that when you've got loads of WhatsApp groups, you inadvertently send the wrong information and share the wrong information with the wrong group, which is what happened in this instance. So this individual thought they were sharing an embargo judgment just with his colleagues at the firm, and instead he sent it to 41 lawyers outside his firm. The whole point with these judgments is that they're sort of delivered in draft so that the parties can see the result, but then that it is formally handed down later on. And in this instance, you can't have details of what that judgment is before it has been properly handed down by the judge. So In this instance, he's had to make an apology to the court, and I think that's the very least of his concerns. It could be that more regulatory issues will follow, but this really illustrates, I think, some of the dangers of using systems like WhatsApp habitually on smartphones for business-related activity. So in this instance, he was trying to use it for the business-related activity of communicating with his colleagues at the firm, and he also used it for the business-related activity of staying in touch with other lawyers. And the key point here is that WhatsApp simply is not a suitable platform for engaging in the sharing of business-related activity. It's designed for personal use. So if you have, a group of colleagues at work and you're going to arrange that you're going to go out for drinks, fine, you can use WhatsApp. But if the minute you start talking about work, and that could include arrangements to cover someone who's on leave, it could include talking about specific cases, specific matters, confidential information. The minute that happens, it simply is not appropriate for that type of work. So don't use WhatsApp for business-related purposes, and indeed I'd minimise its use for anything as far as possible, because of the risks that this article ably demonstrates.
Thanks, Peter. Staying kind of with WhatsApp, kind of just to hammer the point home even further, British soldiers have been ordered off WhatsApp amid fears that sensitive military details could be accessed by Russian hackers. The British Army has banned all its personnel from WhatsApp over fears that the platform can be hacked, despite the alleged end-to-end encryption. Officers from senior to junior posts will face disciplinary action for using the app. Russia has been using UK mobile data to select the airstrike targets in Ukraine. A cruise missile attack last Sunday on a training camp for foreign fighters, which killed 35 and wounded 134, may have used UK phone numbers to locate the base. So this is kind of quite similarly going back to the telecoms, our first story today, but equally again, it is hammering that point home that WhatsApp is not quite what it appears to be on the surface level.
Exactly.
However, go on.
No, sorry, Amelia, finish, go on.
There is, however, an alternative offered up in this story. So they have said that using Signal, which is an alternate app, very, very similar to WhatsApp, is kind of favoured here, because when you're using Signal, conversations are not backed up or stored, they are purely held on the device, and therefore it reduces the chance of messages being accessed. This particular app is actually favoured by MI6, so you'd like to think, and I would just say you'd like to think, that this is more secure. However, as we all know, you can never be fully sure about what you are putting out there.
Indeed, thank you, Amelia. And in this instance, it's the case that it's interesting. This is recommended by MI6, but clearly no one's thought to tell the Prime Minister that he should be using Signal, which his own Special Intelligence Service recommends. Secret Intelligence Service, SIS, MI6. So, it's great to hear that MI6 do recommend using Signal. Why are they recommending Signal? Well, it's basically because messages on Signal are not backed up or stored to any other server. So there's no other surveillance, AI screening and magical analysis, which we suspect Meta are carrying out on WhatsApp messages, so they can work out what adverts to serve on you when you're not looking. Signal doesn't do any of that. It's kind of run on a not-for-profit basis. So it's ideal for work-related messaging, and that's why the Ministry of Defence also recommends it. It also has a desktop application, so you can share things through its desktop application, different formal documents, tables, etc., that you may be trying to share. It's useful for that. Meta have turned around and said, oh, no, and their communications director has said, WhatsApp protects your personal messages and calls with the industry-leading protocol, yada, 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 so they cannot be intercepted by any government. But you'll notice that even the communications director has said your personal messages. She hasn't said your business-related transactions. So I keep on hammering the point whenever I speak at a conference, and I did this at the Risk and Compliance Conference for the Law Society last week. Do not use WhatsApp for business-related purposes. Don't use it to communicate with clients. I'd minimize the use of it within teams internally to communicate messages, because otherwise you saw the problem that they had on the previous story. So lovely story really of, you know, disciplinary offence for senior and junior officers to use WhatsApp. But clearly not a disciplinary matter for the Prime Minister of the UK and his cabinet to use it.
I think it's worthwhile as well to mention here that we have, in the last couple of months, covered the fact that WhatsApp have updated their privacy policy, which would aim to cover use of personal data. And since this GDPR came in 2018, it took till the end of last year, 2021, to sort of hammer out some finer details of the fact what data is held on you. The fact that kind of soldiers in some official positions, including the Prime Minister, are still using this, it is relatively concerning.
Particularly, and as well, for those who think, well, what's wrong with WhatsApp? Why are you giving WhatsApp a kicking? Well, don't forget that they were fined €200 million for data protection breaches last year. I say breaches, infringements of the law, i.e. the fact that what they are doing infringes heavily with what GDPR is asking them to do. And they may be contesting it, but the point is that's what the regulator has said. So, you know, very often people say, well, you know, everyone uses this and we all want to use it. Well, yes. Do you think they fined them €200 million for fun?
Precisely. And I mean, there is the obvious fact that everyone uses it, but the point we're trying to hammer home is the fact that it is not necessary to be used for business purposes. By all means, organise drinks with your friends, speak to your mum on WhatsApp, no problem. But its business transactions should not be carried out on WhatsApp. So our final story for today is mental health charity has suffered a cyber attack. So the Scottish Association for Mental Health has confirmed it was a victim of a cyber attack. The charity, which works with more than 60 communities within Scotland, confirmed the attack in a statement on their website. The attack has been described as sophisticated and criminal and has affected the ability to receive and deal with emails. Some national phone lines were also reportedly impacted, and the Police Scotland are working closely with the charity to aid in its investigation. I think before we even kind of dive into this here, we need to think about the fact that this is not the first Scottish charity who has actually been under fire for a cyber attack. I think it was the end of last year, there was another Scottish charity, it was an HIV charity that actually received a fine due to the fact that they had been breached. And so when we're looking at mental health charities or charities in general, they do handle a lot of personal data, whether it be data on financial side of things where you've been given donations or when you want to consider gift aid, but there is also then the fact that mental health charities will be dealing with data in relation to health, which is considered a special category of data. And because of this special category of data, there should be higher levels of security and protection so that if, in this case, there is a cyber attack, there should not be able to be any access granted to get this data.
Indeed, thank you, Amelia. It's very sad when we sort of see the charities in the third sector being affected by breaches like this. In this instance, it looks like, I'm afraid, this isn't a sort of casual malware or ransomware attack. If it's things like comms that have been taken down, that could be as a result of either a phishing email or spear phishing attack or something else, you know, a user who's gone in there and ended up getting full command and control over the systems of the charity. It goes without saying the volunteer sector, third sector, is incredibly vulnerable to this sort of exploitation because by definition, charities don't have huge amounts of resources to throw at security. Yet, of course, by definition, charities are going to be collecting large amounts of personal data when it comes to donations, fundraising, and then the allocation of support and resources to those that need it. So in this instance, vulnerable people in the community, people who may be vulnerable and may be regrettably rather ripe for exploitation if their data is accessed. It's in this instance, it is good to see that the charity is cooperating with the appropriate agencies. They have reported this to the police. They're working with Police Scotland, And this information has also been shared with the National Cybersecurity Centre, who are no doubt investigating, and they have shared this as part of their weekly threat update. But I think it highlights the need for the third sector to be very aware of these sorts of issues. Do not presume that the hackers are only interested in the banks and the law firms and the accountants and the big organisations with lots of personal data. They're also interested in targeting the voluntary sector for the reasons that I've already outlined, and the fact that by definition simply the security isn't there, so it's very often easier for them to hack and quicker for them to hack and be able to actually exfiltrate money or large quantities of personal data, in some cases a lot more easily than they would otherwise find from businesses in the private sector or public sector. So it's a timely warning for charities. As you quite rightly said, Amelia, there was the HIV charity last year as well that was targeted, and the other charities that I'm sure end up being targeted and perhaps doesn't receive the sort of publicity that this incident has. But I think the key thing is to make sure that where it does happen, that charities are responsible, they report it where appropriate to the regulator. If it involves personal data, they report it to the ICO, support the affected individuals. So if it turns out that information related to donors has been hacked, get in touch with the donors, tell them what's happened. If it's people in receipt of support, make sure they know, make sure they get the appropriate levels of support. And I think do what the Scotland's mental health charity has done here and put up a full notice that says what's happened, where to go for more information. And be very clear and upfront with regards to what's happened, and that actually will end up, I think, giving people more confidence in that charity going forward than potentially if, you know, try and sit on it and hope it goes away, and then the first news anyone hears about it is being a monetary penalty notice and then enforcement from the ICO, for example.
Thanks, Peter. So as well, if you are kind of a listener and you are a part of a charity, there are some guidance on the NCSC website in relation to how as a charity you can protect yourself, and it doesn't have to cost money. It can be just as simple as keeping your systems updated, using two-factor authentication, and regularly updating any passwords which are not the obvious passwords. And as Peter and I have discussed before, the NordPass, they have the 200 most common passwords for 2021, and they are the obvious ones. So if you are going to pick your password, it is always best to kind of use things that are around you as inspiration to just kind of make it a bit more random. But like I said, these are things that do not have to cost money. The charities are obviously not going to have as much money as someone in the private sector, but you can do things to minimize cyber attacks.
Absolutely right, Amelia. What was it? I think the world's most popular password was it 123456? Used
yes,
by 103 million people and can be hacked in sort of 1 second or something like that.
Oh, less than 1 second. Less than 1 second. So yes. And these are all very simple things that you can implement in charities or any sort of small businesses, and they will have an impact, because any form of kind of security that you've got is going to make a difference.
Indeed.
So that was our last story for today. A big thank you to Anson Evaluate for helping to produce this webinar, and we will be back next week. Just a reminder that these episodes are available on our website, our YouTube channel, and podcast channels as well, such as Spotify and Apple Music. Thank you for listening, and see you next week.